Have you reserved some time for rebuttal?
I have, Your Honor, I've reserved 9 minutes. I'm trying to finish the first part in 6.
Okay, very good.
For the record, my name is John Worthington. I'm the plaintiff. The agency has argued that the rulemaking file was not an issue at the agency, on the petition to the agency. What I have here is AR 58 to AR 65. And they're claiming that I did not make the rulemaking file an issue at the trial court or in the petition to the agency is incorrect. The problem that they have is they're trying to relegate the petition to the agency to the cover page, and basically they avoided the supplemental documents. On May 19th, I sent this in, and it says, please add this to the petition for adoption amendment repeal. Now, as you can see, it's RCW 3405-375, which the rulemaking file is part of that statute. And the other problem that they have is that they tried to keep the 17 secret public meetings as part of just the appearance of fairness doctrine argument. So as you can see, I added the 17 secret public meetings to the supplemental. So this is important for the court to understand that they never answered this part of it. They tried to answer the 17 secret public meetings issue in just the appearance of fairness doctrine. Now, here you can see the rulemaking file was before the agency. Now again, the reason this is important is because once you make the rulemaking file an issue at the agency, then it is required to be, the rulemaking file is required to be part of the agency record on the judicial review. So this is what I'm providing direct evidence that shoots down.
Did you ask for that record to be provided?
Did I ask for that record to be provided? Well, I asked to negotiate that record, and I never heard back from them. So as far as, we're at the agency now. So when we were at the agency, I said in AR 236, you'll see me trying to begin the negotiations for the agency record. And I never got a
And
response.
upon judicial review, you didn't seek to have that record?
Well,
added?
I tried, but as I reasoned in my briefing, I didn't have, and there wasn't, a working copy. So there was no way for the court to review the working copy, which is what they used to make the rules. So that would have been futile.
Thank you.
So, and again, here's more 17 secret meetings. This is at the agency, and this is supplemental. And I'm tying the 17 secret public meetings to a violation of I'll just say 375, which is compliance with procedures. Now, and here it is right here, and I'm alleging that this is to the agency, that you don't, the rulemaking file, they violated the rulemaking file statute. So again, this is rulemaking file to the agency.
Well, why is that relevant to us as we are evaluating whether the agency's denial of your rulemaking request was arbitrary and capricious?
Well, this relates to that because the judge, Hurst, trial court judge, she went back and read all of this and she realized that they just answered the appearance of fairness doctrine stuff and they didn't answer this stuff. That's what she sent it back for, was to answer this stuff. Because they answered the appearance of fairness doctrine, and I said, okay, the appearance of fairness doctrine doesn't apply. So, but she noticed when I told her, and she went back, she took 45 minutes to read the record, and this is what she read. This is the part that she read. So I'm getting to the rules review challenge, and there are issues before the court, and one is, should the rulemaking file have been part of the agency record by law, by statute, whether I requested it or not. The statute says once the rulemaking file is made an issue at the agency, all issues brought before the agency, and that's briefed. you can see that I'm saying that by law, they were required to, but they can't. The reason they can't, because right here, they admit that the rulemaking file no longer exists, the working copy. They don't have it. So that's why they had to ignore it, and that's why they had to play this, well, we don't see it thing, where now we go to the petition for judicial review, and again, they're saying I didn't cite, this is the petition for judicial review, this is CP 578. Now you can see the rules review statute clearly up at the top. You can see it right here. Now they're not arguing that it's inartfully pled. They're saying it's not made at all. So here's the record, and you can see.
You're talking about the challenge that the rules are invalid,
Yes.
as opposed to the challenge of the agency's denial of
Exactly.
petition.
Exactly. Now I am pro se. The reason I put the rules review issues before the agency, because I had to understand Rios and some of the other cases that explain, and I didn't quite have a grasp of the statute that said, well, you don't have to bring that issue up before the agency to challenge the rules. So I did it anyway. I put it in there anyway. And so, again, their position is that it wasn't made, and here's CP 579, and I cite it again. Now, but
What are you citing?
this is CP 579.
I know, but we really can't read that very well. So what?
RCW 3405 570 2B2C. They're saying it's not there. The record shows that it is there. Now, I'm out of order here. I showed you, no, this is the second one on the petition. This is actually the third time I cited it in the petition for judicial review. Now, in my opening brief, I cited it again.
And excuse me, you are going into rebuttal time, so just so you're aware of that.
Sure. And so it's there, and quickly, I'll just say that Results Washington and SPE, and from the declaratory judgment side, they assert the authority of the board, and they gave it to the agency head. If you look at Results Washington, it takes it out of the rulemaking from the board that makes the rules and gives it to the agency head that are part of Results Washington and the SPE, and they're overlapped. So it's important that you pay attention to CR 101 and the filing of it and what's the proper way to give public notice that we're going to be doing negotiated rulemaking with all these people. And I'll stop there and I'll let the state come up and I'll rebut. Thank you.
Thank you, Mr. Worthington. How much did he go over?
2 minutes, 6 minutes.
Okay.
Or, I'm sorry, 7 minutes.
7 minutes, okay, so you have 7 minutes remaining for your rebuttal. And you have a cross appeal, would you like to reserve time for rebuttal on your cross appeal?
Yes, Sean, I would reserve 2 minutes.
Okay, very good.
Good morning, may it please the court. July Simpson, representing the Liquor and Cannabis Board. Because this court sits in the same position as the Superior Court, the two issues before this court are straightforward and narrow. First, does John Worthington meet his burden of demonstrating first that the board's denial of his petition to appeal rules was arbitrary and capricious? And second, has he demonstrated that the board's explanation for this denial was insufficient? The court should answer no to both of these questions. Despite Worthington's complication of this case before the court today is straightforward. Because understanding how we got here is important to resolve this case, I will first briefly discuss the relevant procedural history. I will then discuss why this court should affirm the Liquor and Cannabis Board's denial of Worthington's petition to appeal all the marijuana rules. John Worthington filed a petition with the Liquor and Cannabis Board to repeal all of the rules the board adopted to implement Initiative 502. The board denied the petition, explaining the petition did not object to any particular rule, but rather objected to the board's rulemaking process, and the staff believed that the process complied with the APA. The board also noted that Worthington was already challenging the rules in the Superior Court for the same alleged violations of the APA. Worthington then filed a petition for judicial review in the Thurston County Superior Court. The petition did not make clear whether Worthington was filing an original rules challenge or whether he was filing a petition of other agency action, specifically the board's denial of his petition to appeal rules. The board thus filed a motion for more definite statement, specifically asking whether the agency action Worthington was seeking was a rulemaking challenge or a review of other agency action, because the board was unsure which administrative record to prepare or how to prepare its defense. Worthington then filed an amended petition for judicial review, explicitly stating that he sought review of the board's denial of his petition to repeal rules. Based on this petition, the board filed the agency record, the documents it reviewed in considering his petition, which did not include the rulemaking file.
So the complaint does in fact talk about, what are the, 570B and 570C. Wouldn't that suggest that he's also directly challenging the validity of these rules? I know it's not particularly artfully pleaded, but can't we figure out that he's also seeking a direct invalidation of the rules in this petition?
No, although Worthington does cite RCW 3405570 subsection 2, reviewing rules challenge. When you look at explicitly how that is stated, the request for relief, the agency action that's at issue that's stated, and the way it's explained in that petition, it is more reasonable to believe that he is seeking review of the agency action. And what supports that, and what led the board to continue to believe that this was the appropriate agency action at issue, was the opening brief, which went into detail regarding the denial of the rulemaking petition. And it was based on this, in addition to the fact that Worthington did not object to the administrative record that was filed. Worthington has admitted that he recognizes that an administrative record is required for a rulemaking challenge. And although Worthington essentially moved to supplement the record, he sought permission to file with the Superior Court approximately 8,000 pages of exhibits. Worthington ended up withdrawing that request and never served a copy of those proposed exhibits on the board. And again, as I stated, it was really in the opening brief that focused solely on the board's denial of the petition for review, which allowed the board to then file its response brief, which defended the board's denial of the petition. Worthington then filed a reply brief, and that's when he, for the very first time, states that in addition to seeking judicial review of the board's denial of the other agency action and denial of his petition for rulemaking, that he then stated that he was seeking judicial review of the rulemaking process itself. And thus, it's looking at the plain language of these two documents that it's clear that this court need only resolve the issue of whether the board properly denied Worthington's rulemaking petition. So turning to Worthington's appeal, Worthington has not met his burden of demonstrating that the board's denial of his petition to repeal all the marijuana rules was arbitrary and capricious. Worthington asked the board to repeal an entire chapter of rules based on inapplicable and unsupported legal conclusions. Specifically, Worthington supported this petition with 3 arguments. First, with an argument that allegedly secret meetings violated the appearance of fairness doctrine, which Worthington now concedes is an inapplicable doctrine and an argument which he has abandoned. Second, with the additional pages that Worthington has just discussed, which consists of legal conclusions that the 17 allegedly secret meetings violated various provisions of the APA. However, these arguments were supported before the board with nothing more than quotations from the APA and nothing more. Third,
is something more required? If he's telling you the APA provisions that he believes were violated, does he need to provide more in order for the board to engage and address those arguments?
Yes. Here in this situation, the only information that was provided to the board as a basis for why an entire chapter of rules should be repealed was the statement, the board held 17 secret meetings. This is a violation of the APA as proven by, insert citation to, and quotation from the APA. This did not give the board any basis by which to understand what many of these RCWs were inapplicable in this situation. And without more, the board was unable to make a determination that thus they should repeal an entire chapter of rules. And this does not meet the burden that is placed on petitioner in these situations. And frankly, it was based on the quality, excuse me, the third argument that was made is that the board improperly maintained its rulemaking files. That's another addition that Mr. Worthington sent in. However, this claim that the rulemaking file was improperly maintained was unsupported by any case law or any explanation other than Worthington's belief that an agency has little to no control over what should be kept in its rulemaking file. And it was based on the quality and nature of these arguments that the board probably recognized that Worthington wasn't challenging a specific rule, but was rather challenging the process. And because the board believed that they had followed the proper rulemaking procedures, and because Worthington had not, again, provided any specific evidence or compelling justification to believe that the rulemaking procedures had not been followed, the board denied the petition to repeal rules. This decision was neither arbitrary nor capricious. It was reached after...
Does the board have some requirement, as the trial court suggested, to do a little bit more than just saying, yeah, everything we did was fine? Don't they have some obligation to say, we kept our rulemaking file in the proper manner, we held meetings in the proper manner? I mean, does there have to be some level of specificity as opposed to just kind of like everything he says is wrong?
That goes into the cross appeal, Your Honor, which I'm happy to address, which is that this was a petition filed under 3405-330. The prevailing case law in determining what is an adequate explanation is the Squaxin Island Tribe versus Department of Ecology, in which that court said that it's actually it's a very low standard what that explanation needs to state, and it only needs to put the petitioner on notice as to why the petition is being denied. It can't just say denied, and that would be inadequate. But it also needs to not frustrate judicial review, which in this situation it has not. And again, so this decision was not arbitrary or capricious when looking at the fact that it was reached after due consideration of the facts and circumstances in this case. Here, the board considered very conclusory and wild allegations, and compared it with the requested relief. Here, that requested relief was the repeal of an entire chapter of rules which regulate over 1,700 license holders in a multi-million-dollar industry, which had been going on for several years, and it was the result of several years worth of rulemaking efforts. Thus, the decision to deny this petition cannot be deemed to be a willful and unreasonable action taken without consideration and with disregard of the facts and circumstances. Or,
I'm talking less about the decision at this point, but about the reasons for it. And it sounds like if this is a multi-million-dollar industry and it's so important, doesn't the board have to do more than just give us a sentence as to why they're denying the petition?
under the Squaxin Island Tribe standard, no. That in some ways that confuses the merits of the denial along with the explanation of the denial. When you look at the Squaxin Island Tribe case, the facts of that case included there was quite a bit of investigation that was given, quite a bit of information that was given to the Department of Ecology as to why that rule should be amended or changed. And one of the justifications that the that the Department of Ecology gave was that there were staff shortages and they didn't have the money to do the research that was necessary. And there was another sentence that was given. That was a 2-sentence explanation, and this court has held that that was sufficient because the standard when looking at a petition filed under 3405-330, it's a low standard, and it merely asks, did it put the petitioner on notice and did it frustrate judicial review? And in this situation, this explanation, based on the extremely conclusory and bare allegations made, and compared with the requested relief, it was an entirely appropriate explanation that was given. It need not reach the merits. That was made clear in the Squaxin Island Tribe standard. And again, in Squaxin, the court noted the petitioner's true grievance was with the merits of the denial, and a challenge to the explanation is not an adequate substitute to a challenge of the merits. Here, also, Worthington's true grievance is with the merits of the denial. What he would like is for the board to, in fact, grant his his motion, to grant his petition, but he's challenging that under the guise of challenging the explanation as being inadequate. And the Squaxin Island tribe held that that's not an adequate substitute. Here, Worthington's grievance is that he believed that the board conspired with stakeholders to create a shadow government designed to hijack the rulemaking process to reach an unspecified nefarious purpose. And a further explanation of that by the board would not address what Worthington ultimately seeks, which is for the board to grant that petition, and thus a remand to the board for a better explanation would no way address what Worthington actually seeks to attain, and would be a waste of judicial resources and the resources of a state agency. For these reasons, this court should affirm the board's denial of Worthington's petition to repeal rules. I see I have 30 seconds left. If there are no further questions, I will waive those 20 seconds.
Are we moving to adopt any further questions?
Thank you.
Thank you, Ms. Simpson. So here's a few seconds left. You can add them to her rebuttal time. Mr. Worthington, you have 7 minutes.
Thank you, Your Honor. You know, they keep saying that the board wasn't given this rulemaking file issue. And I'll read it again. Prior draft versions of the rulemaking file prior to the adoption of I-502 rules no longer exist, as rulemaking files are continuously updated until the completed and final adoption of the rules. Now, in the public records case, I'm sorry to bring that up, but they brought up this working file theory, where they can create a file, work from it, and then after they're done making the rules, they can just start taking stuff out. And this is why I'm here, is to make sure that the court upholds the law on how they're supposed to make rules. And this whole process starts with the CR 101 and notifying the public that we're going to do rulemaking, negotiated rulemaking with all these factions, so that the marijuana activists, somebody like me, the neighbors waiting, hey, there's a marijuana activist guy, so I can see what they're arguing, so I can give rebuttal. And so this whole process, as I saw it, was the governor interfering, SPE interfering, these are grants, federal grants, and they couldn't just show up and say, well, 7 out of 10 doctors say marijuana is bad, because that wouldn't give them the results they were after. So when they met with the board in the 17 secret meetings, they talked about the 1,000-foot rule, they talked about how many stores, so they talked about the rules, and that stuff should have gone to the rulemaking file. As you can see, after I showed you the record, they ignored that part of it, and what you're looking for is the well-reasoned, the path that they took to get at the decision. Now, in their discretionary review, that was their standard. But when I brought up and did a more careful analyzation of the Squamish tribe case, which shows here's what would be a well-reasoned, they changed their position that it's not a well-reasoned standard, but it is a well-reasoned standard, and the trial court judge was right to send them back to answer the supplemental stuff more thoroughly, because they didn't. They didn't answer it, they didn't put it in there, they just said, we believe we follow the rules, and that's not enough.
So what kind of answer are you looking for?
The answer I would be looking for was, we checked the rulemaking file, the working one, whatever they want to call it, and we've decided that based upon the rulemaking file, the stuff from the 17 secret meetings was either in there or not, or the other issues that I brought up were there or not. Did they or did they not have the original rulemaking file, which is really the only one there is. There's not a working copy, there's not an initial, there's not a final. That's repugnant to the statute. You just can't you can't assemble a rulemaking file and make rules and then start taking stuff out so the public can't see and rebut the other side. I don't know if I have enough time to explain to you just how important that is, but the silent part was, well, we got to make it more expensive so the juveniles can't get it. Well, somebody like me could start pointing out the problems with that tact, but during the course of the rulemaking, I wasn't made aware of it. Now, you are sitting in the same position as a trial court, but this is not a new trial. They put all their eggs in the appearance of fairness doctrine basket. So they had nothing to appeal. The only thing they had to appeal was to get a second kick at the cat. That's all they had, because they won their only issue that they argued, and I said, yeah, you won it. So what they had to do was they had to file a discretionary review and hope that you give them another second kick at the cat that they should have made on the supplemental stuff that Judge Hurst obviously saw that they didn't address. That's why it took her 45 minutes to go back and read the agency record. So this is a very important issue. CR 101s have to be filled out. I got another case that's coming up, the exact same problem. The CR 101s are not being filled out. Results Washington is interfering with the rulemaking process. These people with federal grants who can't really work on rulemaking, they're doing this through this separate process to get information. They get into the separate process to give information, and they start commenting on rules. Well, when they do that, all that's got to go into the rulemaking file. Now you got the Attorney General conducting rulemaking also, and if you read the record, you'll see he's giving his personal comments, it's there on the record. I can send you a letter later to explain where it's at. So you got all these interferences from people that are in charge of the agency, and they interfere. So that's where the declaratory judgment comes in. Because they didn't put it in the rulemaking file, because there's subordinates to the governor and the AG, I need that declaratory injunctive relief to protect the rulemaking process, which I can see from the case with the Washington Department of Agriculture. They got a problem in that they don't want to put in the CR 101 their negotiating rules, who they're negotiating rulemaking with, and then organize meetings in the public so the public can see who they're meeting with, so that we can give proper rebuttal and a meaningful adversarial testing of the other side's comments that are important when it comes to an issue like marijuana. And it keeps the pursuit to get exclusive rights. So you'll seek those exclusive rights through these secret channels. This court has to cut that off. The court has to say, no, you gotta fill out the CR 101 right. You gotta put negotiated rulemaking from the start. You gotta eliminate all these interferences. And if you don't, I'll be up here and I'll make a career out of this. Thank you.
Thank you, Mr. Worthington. Ms. Simpson, you have a little over 2 minutes to address your cross appeal.
Thank you, Your Honor. Mr. Worthington has just argued that the standard for an explanation is that it be a well-reasoned standard. However, the Squaxin Island Tribe made clear that that is not true. The standard under that case is, this court has stated that we evaluate the sufficiency of an agency's explanation under RCW 3405-330 in light of its purpose to facilitate judicial review of whether the agency's decision not to engage in rulemaking was arbitrary and capricious. Thus, the purpose of the explanation is for that purpose alone and not to satisfy the curiosity of the petitioners that file these petitions. When you look at the facts of the Squaxin Island Tribe case, there were 2 reasons that Ecology gave. The first was that there were staff reductions and potential new cuts that limited the agency's ability to do comprehensive work on these rules. And second, that additional information was required regarding the Johns Creek Basin, which was needed before a comprehensive rule amendment could be undertaken. The Squaxin Island Tribe argued that that was insufficient and it did not specifically address their concerns. And that is very similar to this case here, where the tribe was looking for a more direct explanation. And however, this court has specifically stated that that's not the purpose of an explanation under the requirement of 3405-330. And thus, the board's explanation here was sufficient. Again, we're here, we evaluate it only in light of its purpose to facilitate judicial review of whether it was arbitrary or capricious. And here, that standard has been met. And this court need not remand to the board for a further more comprehensive explanation, this court should affirm the board's decision denying the petition. Thank you.
Thank you, Ms. Simpson. Thank you again, Mr. Worthington.